So, in reading through some of the comments on my posts lately, I've realized that there's a major misunderstanding in the public about who can prosecute and who can pardon in the United States. And of course, I'm discussing this in the context of the ICE officer shooting in Minneapolis. The President of the United States cannot pardon an ICE agent for state level charges because state criminal authority is separate from federal authority. The United States is built on the idea of dual sovereignty. Now, what that basically means is the federal government and the states each have their own sovereign power to make and enforce law. It's not that there's one boss over the whole country. It's that the system operates between the states and the federal government as co-equal powers. That co-equal status is confirmed in the 10th Amendment to the U.S. Constitution, which basically says that any powers not granted to the federal government and not explicitly prohibited to the states belong to the states or to the people in general. So states have their own criminal codes and their own prosecutors. But there is a couple of catches and a couple of big exceptions to that. Most of those exceptions are baked into what's called the Supremacy Clause in the federal Constitution. That says that the federal law essentially trumps the state law if the two clash. That doesn't give the federal government unlimited power, but it does mean that federal authority wins out if there's a direct conflict. So, under the system of federalism that we have in the United States, states can prosecute their own violations of state law. The federal government can prosecute violations of federal law only. And the two systems operate independently, although they do frequently interact. The Minnesota shooting of Renee Good provides a good opportunity to examine these concepts in action. The federal government has asserted control of the investigation and barred Minnesota state investigators from evidence, citing that the ICE agent was acting within his federal capacity. Minnesota officials certainly disagree with that and want to pursue their own review. Here's the key. If Minnesota finds sufficient evidence to prosecute under state law, that's state sovereignty in action. The President of the United States has no consequential authority to pardon someone for a state-level crime. Pardons extend only to federal offenses. And that means that even if the White House supported the ICE agent politically or publicly, the President of the United States cannot stop a state prosecution with a pardon. That's not theory. That's how federalism works. Presidential pardons apply to federal actions only. If a state chooses to charge someone under state criminal law, only the state's executive can grant clemency for those charges. And that certainly doesn't appear like that's going to happen in the state of Minnesota.